Good evening. I'm attorney Lawrence Berliner. I'm an attorney in the field of special education law. And tonight, I'm again with our co-host Jane Faherty, who's the director of the Stamford Jewish Community Center JumpStart program and a self-styled advocate. She'll discuss her background and credentials. We had a lot of questions from our last webinar, and we've asked Allie Grafman and Marla Wayne, who graciously agreed to appear for a second time in a row to try to address questions and concerns, some of them left over from last time. And we have quite a few questions from, I would say, we've had almost 200 people register for tonight. I don't know if everybody will show up, but we certainly welcome those who are here already. Jane and I are continuing to present our Zoom webinars because we are part of a community of concerned parents and professionals, as Allie and Marla are, and those who are joining us each webinar. We're still learning how to connect with one another. While the past we were talking about COVID-19 and the pandemic, school closures. Since May 11th, we've had the official pandemic declared over. I don't think it is, but that's my personal opinion. And Jane and I have been moderating a series of webinars to address issues that are coming up in these unprecedented times that have an impact on your child's special education journey. And we try to help by empowering parents and others who are here with the information we present. As I mentioned before, Allie Grafman and Marla Wayne are our special guests tonight. And this is our last program for the 22-23 school year. And we're discussing a whole host of issues that have come to our attention through the questions that have been presented. For those who are new to our webinars, we ask that your questions be put in the Q&A format, not the chat format. The reason we ask that, this webinar is being recorded by Zoom, and in order to maintain as much privacy and confidentiality as possible, we would like your questions in the Q&A section at the bottom of your computer screen. That is not recorded. Whatever goes into the chat is recorded. Another housekeeping note, Jane and I and each of our guests have put information in our chat section as far as contact information and resources. We're going to have a slide at the end of the webinar, and this contact information will also go out to those who get a copy of tonight's recording. Apparently, Zoom has changed some of their format, and we're no longer able to upload information to the chat before we log on. As I mentioned before, this webinar is being recorded. A copy will be provided to each person who has registered. The information provided during tonight's webinar does not constitute specific legal advice regarding you or your child's circumstances and should not be relied upon as such. The webinar does not establish an attorney-client relationship with myself, Attorney Lawrence Berliner, or a professional relationship with Jane Faherty, the Stamford JCC, and tonight's presenters as well. By signing up, you've agreed to receive information about future webinars and events from the Stamford Jewish Community Center and the Law Office of Lawrence Berliner. Zoom is a third-party provider and is not an agent or associated with the Law Office of Lawrence Berliner or the Stamford Jewish Community Center or tonight's presenters. The information that we are presenting is based upon our experience as practitioners here in Connecticut. So it's based upon our experience here in Connecticut and Connecticut law and federal law. We do have many guests who've come from other states and many guests who've come from other countries, but we just want to let you know that what we're talking about is what goes on here in Connecticut. So without further ado, I'll turn this over to Jane, who will introduce herself, and then we'll do a brief introduction from two of our guests and get to tonight's questions.
Thank you, Lawrence. It's a pleasure to be here again tonight. I can't believe we're at the end of our third year, in fact, more than 3 years of doing this at the end of another school year. It's flown by. I wear a number of different hats. I'm the executive director of a program called JumpStart, which is located in both Stamford and Norwalk. It's a toddler classroom for children with developmental disabilities, where we offer one-to-one student-to-teacher ratio. I then help those students transition into the public school if they're deemed eligible in or around their 3rd birthday. In addition to that, I work for the Susan McGraw Foundation and help look for community partners to support help provide different resources for this community throughout Fairfield and beyond. And in addition to that, I do have my own private advocacy business as well. But it's a pleasure to be here again tonight. As Lawrence said, COVID pandemic has ended, but we are still seeing the fallout of COVID and the impact it's had both on the students as well as the educational system. The resources are more scarce, and that has presented many challenges for students and parents alike. But that doesn't mean that the IEP shouldn't be honoured and that the individual needs of the student shouldn't still be met. So it's a real pleasure to have Allie and Marla here again with us tonight. And we will try to endeavour to get through as many questions as possible, but we have received a tremendous number. So if you need any support after this webinar, please feel free to reach out to any one of us for additional support and insight on how to navigate the next steps. So without further ado, Allie, if you'd like to say some words first, please.
Thank you. Good evening, everybody, and thank you for joining us, and welcome to all those new attendees. And I'm really happy to be back and doing the last webinar of the 2022-23 season. I'll make a very brief introduction because I know we want to get to the gist of everything tonight, but my background has been in public education all my adult life. I've been a special education teacher as well as an administrator. And about 9 years ago, I thought I retired, but I really didn't. I became a special ed advocate and now have my own company. I work with families and students in all aspects of advocacy, including supporting families to enter into a PPT. I attend PPTs. I work with families, with students on 504 plans, and also work with families to assure them what resources there are available to them. I love what I do, and I'm really happy to be able to see everybody on the screen, but work with everybody here tonight and help answer your questions. Thank you.
Good evening, everyone. I'm Marla Wayne. I'm a special education advocate. I work for families who need help for their children in different areas of Connecticut with needing help through the school districts, and also with attaining services through outside government agencies. My background is that I have been advocating for 10 years, and I have 2 children who have IEPs, one who's graduating high school right now and working on accommodations for college, and another one with significant disability. And he is in a transition program. He's 21. So I've run from the beginning of time with him when he was 3, starting in preschool, till currently now being in a transition program, having to advocate for him with the school district, and again, with attaining services through DDS and DSS. I appreciate everyone joining us tonight, and I look forward to our continued conversation.
Well, we're at the end of the school year, and parents at this time of year should be looking backwards to see how we started and getting ready for the next school year. So parents' input perspective is very important to see if the goals and objectives have been mastered or there's satisfactory progress. And it's important, and I think through our questions and hopefully our answers as well, you'll see how empowering parents with knowledge, resources can help ensure that your child receive what's called a free, appropriate public education. So we have a number of questions. I don't know where we'd like to start, but we should start somewhere. So
I was going to say, Lawrence, I would like to start by asking a question to you. The four of us spoke briefly about this beforehand. And this for you, Lawrence, but also Allie and Marla, please feel free to dive in as well. So this is regarding seclusion and restraint. I think, first of all, Lawrence, if you could describe what seclusion and restraint is, because sometimes parents are not actually that clear in terms of what the definitions are. And then the question is, how can you request that seclusion or restraints not be used with your child and have it honored in their IEP?
Well, some of this is based upon Connecticut state law. Before I answer the question, I should point out that our United States Senator Chris Murphy has sponsored legislation that has been reintroduced for this session of Congress called CASA, K-A-S-A. The K deals with keeping, and one of the S's deals with keeping students safe. And it's on the federal level to basically extremely limit or prohibit seclusion and restraints. There is a bill, and I, along many other parents and advocates and attorneys, submitted comments and testimony earlier this session of the General Assembly, doing this stateside. I don't know where the bill is right now. Tonight is the last day of the Connecticut General Assembly, so if the bill does not pass by midnight, it won't, but it's going through the committees. So what seclusion is, you're basically isolated, you're taken out of the regular classroom and put into an alternate setting. Often that alternate setting is a seclusion room, and we have standards, unfortunately, very detailed standards. And when I say unfortunately, I don't think any child should be in a seclusion room that's padded, has locks on it, and the child is alone. If a child has to be secluded, there's something that needs to be addressed with the IEP, the behavior support plan, staffing, other resources. So seclusion is isolation from the regular classroom and your peers. Restraint can be anything from a physical hold to a 5-point restraint. 5-point means a child is on the ground, and I've had situations where there are 4 to 5 adults holding a child down. I've seen situations where they have seclusion belts or other ways of restraining a student. From my own perspective, seclusion or restraints is a failure of programming. And the only time I find that it's necessary is in a bona fide emergency situation. There is a standard, a danger to self and others. If it's an objective standard, that's fine, but often it's subjective. And what I mean by that, we have a child who's acting out, and the immediate response is seclusion or restraint. And seclusion, a child acting out is at multiple levels. If the child is injuring self or others, that's one level. But if it's tipping over a desk or throwing a book on the floor, I don't think, as I said before, that's a failure of programming. So I think parents should be knowledgeable. Here in Connecticut, we get procedural safeguards on seclusion and restraints. Parents should be knowledgeable of what that document says. That's provided in addition to the special education procedural safeguards. If the legislation passes at the state or federal level, there will be substantial changes to the use of seclusion and restraint.
That's great, thank you. It's such an emotive conversation. It's very difficult when I've visited schools and I've seen it in action. It's really hard to witness and see. And I know many parents get very upset when they know that their children have had these traumatic experiences. So thank you for sharing that, Lawrence. It's really important to advocate and to campaign and lobby against this sort of thing and to contact your representatives if you do have concerns. The more voices that can come together, maybe the bigger impact we can have in this regard. So it's important to speak out. Another question that we had tonight, which is we haven't really tackled before, Allie, I'm going to start with you, but Marla, please feel free to jump in, is you've mentioned earlier when we discussed this briefly, how can you go about requesting a gap year for a child from your district?
Okay, first of all, I think to define a gap year, I'm assuming that the question originated about an extended year after the 12th grade, okay, between 12th grade and the next steps, which could be vocational or post-secondary school. So it's that year after 12th grade. I guess what we need to remember and to understand is that a student cannot graduate and accept a diploma and also have a gap year. So requesting a gap year means that we withhold the diploma. The student most likely can walk with the class, and that's something that has to be discussed with the district, walk for graduation with the class, but no diploma is provided to that student until the gap year is ended. So how do we get that gap year is the question. And I just recently went through this with a client. I'll give you a brief scenario. The student up until very recently in his 12th year of high school, the parents, the guardians, and the student realized that he wasn't ready to graduate. Well, what do we do when graduation was 2 weeks away? In reviewing the student's file, I realized that there was no transition assessment, which is a primary tool, I'll repeat, an essential primary tool to determine the student's readiness to graduate and receive a diploma. And every student with an IEP has to have, by state law, transition goals and objectives. This student had transition goals and objectives, but it was not based on any evidenced transition assessment. So the process began with requesting a transition assessment that was done very quickly, but appropriately. And with that, we developed transition goals and objectives according to the areas that the student needed, evidenced by this assessment. And now the student has an IEP that is appropriate because it has those transition goals that the student is not able to achieve within the 2 weeks before graduation. Thus, he's eligible for that gap year. Where that gap year is, it depends upon the student. Sometimes it's within the high school. Sometimes it could be a transition program that the district facilitates outside of the high school. There's many placements for a gap year. But the question is that we need to evidence the fact that the student needs those transition goals. And that's how we accomplish that. Marla, I don't know if you have anything to add to that, but it was a good question.
Yeah, the only thing I would add is that the next steps, once you understand that you're able to have a gap year, or that the district agrees that your student can have a gap year, is to decide where that gap year is going to be. And as you mentioned, it could be in a transition program or a higher education program. But again, the most important thing is, in order to get that or keep that they cannot get their diploma or accept their diploma until they're done under the purview of the school district.
And I just wanted to add that the graduation is a social graduation, not a legal graduation. And that means that the student would participate in all the end of the year activities except receiving their high school diploma. Because once a regular education high school diploma has been issued and received, the student loses their eligibility for further services after the date of graduation. And it's very, very important that parents and young adults, if they're over 18, understand their rights and how transition services will prepare them for life after high school by focusing on furthering their education, employment, and if necessary, working on independent living skills. All of that is designed to promote, if they're going to go to college, we want to make sure they have the skills to go to college. If they're going into a vocational training program, the same thing. Are they going to work independently or with supports? Are they going to live independently or with supports? These are all questions that a good transition evaluation will start to assess commencing at age 14. That's the law here in Connecticut, that the schools have to start their transition planning at age 14.
We've had such.
I'm sorry, one thing I forgot to mention, there's no limitation for just one gap year either. The students now could go through the age of 22.
That's correct.
Good point. It could be more than a year, and that's something to keep in mind. Yeah,
Yeah, and I was going to say, we've had such an eclectic group of questions tonight. There seems to be no rhyme nor reason to them. So I'm going to switch from transition to transportation. So I'm going to ask Marla this question, and again, everybody please chime in. So what determines, Marla, the eligibility for special transportation for an out-of-district placement?
Yes, so it would really depend on if the out-of-district placement was made by the school district, in which case I would assume and make sure that the transportation is included on the IEP. And if it's an outplacement requested by the family or the parents, then I would try to negotiate to have that be the case, but it's not a done deal that that's definitely going to happen. If there is another student from the same district going to that school, you usually have a greater chance of receiving the same transportation because they can the transportation would be able to bring more than one student to the same outplacement.
Yeah. Sorry.
We received a question this evening about what happens when a school district does not respond to a parent's request for an independent evaluation. When a school district completes an evaluation and the parents disagree with the school's evaluation, they can request a publicly funded independent evaluation. And when that request is made, the school district has two choices. They can say, yes, we'll pay for the evaluation if the evaluator meets our criteria for outside evaluations, or they can say no, and then they have to file a request for a due process hearing against the parents to defend their evaluation. There isn't a third choice of ignoring the parents altogether. So when a parent's request for an independent evaluation is submitted to the school district, we have State Department of Education guidelines on independent evaluations. These state guidelines are on the State Department of Education website. ct.gov is how you access the state websites. And according to the guidelines, the school district should provide a response within 10 days. And then after that, if they're going to file a request for a due process hearing, then within a reasonable period of time, they have to file for a due process hearing. So what happens if there's silence? My suggestion would be either speak to the school team or special ed director and find out what their response is, or the parents can file what's called a complaint resolution complaint, a CRP complaint, with the State Department of Education and ask the state to get involved and investigate the complaint that alleging the school has been non-responsive to a parent's request. So the policy or the guidelines said take up to 10 days to respond to the parents. The federal law requires the school district to file for due process within a reasonable period of time, which is not defined, but it's usually 30 to 45 days. And if there's no response, consider contacting the State Department of Education.
So this is a question we get asked, or it's related to the IEEs that Lawrence was just mentioning. What do you do if a school does not think that your child requires related services or an IEP or 504? And this is open to everybody.
Yes, you can ask for a PPT more than once, but you can also attain your own evaluation and then go into a PPT where you've made a referral to special education and show this report that should indicate where the areas of deficiency are or difficulty are and that are adversely affecting the student's education. But it's once you ask for special education or make a referral, it's not over if they say we don't agree or we don't want to do an evaluation. You can continue to ask for PPTs at any time.
Yeah, I think that's an important concept that many parents take the school's refusal as a dead end. And it's not. As Marla suggested, you can go for your own private evaluation and present it to the school. And also you can build up a case, so to speak, where you save your child's a portfolio of records, like any emails from teachers that describe your students' distractibility or low test scores or whatever. Save everything and ask for copies of all of as much work as you can get. So you create a profile that's indicative of a student that is struggling. And then you can go back with concrete evidence. Look, you said he was doing well, but I have something to show you and share with you. So parents can do a lot and empower themselves. And it is not a dead end when they say, when the school says no, you can come back and ask for a PPT.
During COVID, Lawrence and I spent an awful lot of time talking about data. And data, as you mentioned, Allie, can present in numerous forms. It can be letters, communications that you've had with the school district or with a teacher. It can also be your own anecdotal observations. If the school district is saying your child is able to read independently, here's some examples of the books. But when you're at home reading with your child, you're noticing that your child is not reading accurately, fluently, decoding, is substituting words. You can showcase that. You could take a video. You can make records of where you see your child not reading fluently. You can show examples of maybe letters that your child has written, birthday cards to families and relatives. It can be anything can count as documentation to go in and say, actually, I have seen, and this is evidence of my child not being able to grammatically spell, not being able to spell accurately. The grammatics is incorrect. Their understanding of math comprehension is not where it should be, and it's not on par or in line with their grade. So don't discredit your anecdotal observations and interactions with your own children, as well as being data that you can present and take to a school to validate that you don't believe that they're functioning at grade level or that they're making satisfactory progress. You can look at report cards depending upon the grade that your child is in and use that. Has your child's grades been declining over a period of time? Use all of this as information and data. You know your child best, and you might see them struggling in different ways at home. I've known students where the teachers have said, oh, they can recite the alphabet, they can decode CVC words, but at home, nobody else saw that. So don't diminish what the data that you present and bring to the table as well. It's extremely important.
And also make sure that you receive curriculum-based assessments, copies of them, benchmark assessments, district assessments, state assessments. Make sure you receive them, make sure they're on par with what's happening in reality, and make sure that they're updated. That usually you should receive some of this testing 3 times a year, sometimes 2, depending on what kind of services your student has. And of course, all students receive assessments on it in a typical classroom as well. So you should make sure that you receive all of this paperwork and that you keep track of it, and it's based on reality of what's actually happening with what you witness at home.
And just to add to that, just do an analysis of the trend. If you have like 3 years worth of data, start with year number 1 as your baseline and see how year number 2 and 3 is trending. Are the arrows going up, meaning your child is improving over time? Are they going sideways, which means there's no progress? Or worse, the arrows are going down, which means your child is regressing. And I see STAR testing, DIBELS, I see smarter balance testing, OLSAT. There are all kinds of testing that's going on throughout the year, whether a child has an IEP or does not have an IEP. There should be some way of measuring progress. And understand, also the other thing is understand the lingo. I have parents say, well, my child has an FMP 22 or a DRA 22. What does that mean? Look it up. And I'm parents are, gee, that sounds like a great score. But when you find out your child's in 4th grade reading at the 1st grade level, suddenly it's that cold water splash in the face. And parents need to be, knowledgeable and look. You can look up Fontes, Pinnell, and DRA and teacher college numbers, and just see where your child is within a range. Lexile score is another one that's often, and that shows up on the Smarter Balance. What is your child's Lexile score? They don't tell you what the score means. You have to look it up or ask the school to look it up. I've been at many PPT meetings this year. I know the answer, but I always ask, what does this Fontes Pinnell score mean? And teachers don't want to face parents and say you're 3, 4, 5 years below benchmarks, but it's important information for the parents.
In terms of this time of year, obviously the school districts, educators, advocates and attorneys are extremely busy. And we had a question saying, is it appropriate for district to cram, and the word cram was used, triannual transition planning in the same PPT and the review of IEP goals all in one meeting? I feel that it's very important to set an agenda out before you have a meeting to let the team know the items that you need to discuss, and to let them know that if you're unable to do that in one PPT meeting, you anticipate and will require another PPT meeting held very soon afterwards in order to address all your needs. But Marla and Allie, what recommendations do you have for families facing this situation, particularly at this time of year?
Yes, I would recommend that if you're going to be reviewing triennial assessments, draft goals and objectives and progress report in one PPT, that you receive all of the information in advance of the PPT so that you have time to review it. Also, some school districts do meet with the parents to review their assessments, their triennial assessments before a PPT, to work on explaining what it means to them. But unless you have a significant amount of time, it's hard to do that without having the paperwork ahead of time. So that's really essential. And then another thing that I often do is that if we see changes that we want made on the IEP, I ask the district if they're willing to collaborate and work on the goals and objectives back and forth before the finalized document is sent to us, so that we don't have to write an addendum or an amendment for the IEP. So long and short, I would request as much information as possible in advance of the PPT.
Good point. And discussing it with the author of any evaluation can also help parents demystify information and make sure they are understanding what's being written. We received a question tonight and prior to tonight about daycare centers and what are the laws that apply to daycare centers. If they receive federal funding, Section 504 of the Rehabilitation Act is a federal anti-discrimination law. Regardless of whether the daycare center receives federal funding, we have the Americans with Disabilities Act, which reaches daycare centers as places of public accommodations. Here in Connecticut, the United States Attorney's Office, which is part of the Department of Justice, has investigated several complaints against daycare centers that are discriminating on the basis of a disability. So in order to establish coverage under the Americans with Disabilities Act or Section 504, we have to establish a disability. And if that is satisfied, it's called a physical or mental impairment. And when it comes to the daycare center, what is it exactly you are asking them to do? Because your child is entitled to what are called reasonable modifications and reasonable accommodations, which I won't get into the details tonight due to time constraints. If the request for accommodations or modification is unreasonable, then the daycare provider doesn't have to provide it. So what are some of the outer limits that make an accommodation or modification unreasonable? It could be programming, it could be financial. If you have a daycare center, and I'm making up numbers, that their income is $200,000 a year, and you're asking them to spend $50,000 a year to accommodate your child, that might be an example of something unreasonable. What should happen, there should be no categorical decisions. We don't accept children with autism or intellectual disabilities. There should be a case-by-case determination as to whether or not the daycare provider can meet the child's unique needs. And again, as I mentioned, there are outer limits as to what is reasonable. And that's done on a case-by-case basis. The United States Attorney's Office in Connecticut is located in the federal court in New Haven, and there is an assistant U.S. attorney assigned to handle disability discrimination. I don't remember her name, but contact the U.S. Attorney's Office in New Haven if you believe that your daycare provider is violating either Section 504 or the Americans with Disabilities Act, especially if they're making categorical decisions. We don't accept children with that disability or any disabilities. The question is whether they're reasonable accommodations. So this is something that I am privy to all the time. So typically, in my experience, what happens is that children are enrolled in a daycare situation, and quite often the educators working in that daycare, whether they're the lead teachers or the assistant teachers, might not have the level of education, understanding, and expertise to individualize a program and meet a child where they're at, whether it's sensory, communication, social, emotional, or physical development, if there are developmental delays. So I get asked to go and observe the students that might be struggling within that environment. And quite often I speak to the teachers, and it's not that the teachers don't want to meet the child where they're at, it's that they don't have the understanding, the resources, or the student to teacher ratio to help engage that child or keep that child safe. For example, if a child is very orally fixated and is mouthing non-edible items. So quite often it's about understanding if that is going to be the right fit and environment for your child. And do they actually, as Lawrence mentioned, the resources. Sometimes it's not through a lack of wanting, it's just that they honestly do not have an understanding, expertise, or the student to teacher ratio to support your child. Some of the educators I've spoken to would welcome the training, but again, they don't have the resources from their within the organization to be given adequate training. So if you are in a situation where your child is in a daycare and you are dissatisfied with how they are being supported, you can reach out to me. My team and I go into classrooms. We can observe and provide the educators with some strategies and ideas on how to engage the child and how to collaborate if they're in birth to 3 with the birth to 3 providers. So sometimes it is a lack of understanding and knowledge as well as resources that leads to the decision that it's not the appropriate environment for a child versus
them automatically saying because they have a diagnosis they're not going to help that child. It can be that as well at times, but quite often it's due to a lack of understanding and education within the daycare setting, unfortunately.
This is a question I'd like to toss to the three advocates here. When you're assisting a family, are there documents that you're looking for, or do you advise parents to have like a binder or a folder with certain documents that help you in a, if they're organized in a specific format? So when you go into PPT meetings or other kinds of meetings, you're in you or the parent is in the best position to have that kind of documentation. I mean, I have binders of records, so that's what I start with, and then so I don't know how you as advocates approach a family.
I'll start by saying organization is key. Because at a PPT meeting, you are multitasking. You're trying to listen, you're maybe taking notes, and you're looking up your child's information. So I always go in with my files and with my tabs, and IEPs are in one section, evaluations are in another section. I also have sections for emails from communication with the teachers or various staff. So the different sections are, very, very important to have. I also think that if you are looking for eligibility, for special education as in an initial PPT or an eligibility PPT, you really need to come in with some charts or evidence to show lack of progress or insufficient progress or regression. So you come in with those charts, and I usually make copies for the team to pass out, because it's very different verbalizing it compared to actually giving a piece of paper with a chart and seeing it. So any visuals like graphs or charting or any kind of as I said, visuals would be very helpful. So organization is key, but also I advise clients to tape record, especially if you feel that the PPT can be a bit contentious or disagreeable. And that is certainly a way to keep track of what the ongoings of the PPT was about. So.
Yes, in addition to having a binder or separating by type of document, I also do a file review. So that's a summation of all of the documents, which include the IEP, the evaluations, progress reports, data of any kind that we discussed a short time ago in this meeting. I have it in one spot so that it's easier to access, but if I need to pull out the information separately, meaning having more information that's already on than what's on my file review, then I do have it on the side, easy to access. But I find doing a file review is really much easier for me, because I can search. If I use a Word document, I can search for the date or IEPs versus evaluations and find it pretty quickly, because I've summarized most of the information that's important in each of the types of paperwork.
Yeah, timeline is really helpful. So when I meet with families, I start off with a timeline. When did they first have the concern? And then I work back and then forward to where we are today and what led them to this moment in time. The documentation is really extremely important. It's not just the documentation in terms of reports and things. It's also if they have copies of communication that they've received from the school or have indeed written to the school, whether it is the school nurse, whether it is their kindergarten teacher now they're in 3rd grade, just any kind of communication that you have received backwards and forwards from the school. It could be, when you got the phone call from the nurse 3 times a week that your child had a stomach ache and needed to be picked up and go home. So all of these things can help build a picture. As an advocate as well, because I do work with children and I tutor and so on. So I always actually ask to meet the children that I'm advocating for, so that I can, if they are able to articulate and explain to me some of the experiences they've had in a school classroom or how they feel they're interacting with material, then I find that helpful as well, because it's not just the teacher's interpretation of how a child feels that they're interacting with material. I can actually ask the student themselves if they are able to articulate. And for others that might be more behavioral, I like to connect and engage with them just so I can have an understanding myself as to how I can maybe support the family to advocate for the most appropriate program for that student, or the most appropriate setting for that student within a school setting or classroom setting. So, but a timeline is very helpful. It's also helpful for you as a parent, because you might forget, you might be, oh, that was right, that was actually second grade, not kindergarten. And it can help you really connect the dots and align the data. And organization is key. A ring binder is great. If you're more electronic, you could do it, through tabs on your computer screen, whatever works best for you. And some families like more visuals and pictures and photos to help them remember the progress that their child was making developmentally in the different areas too.
We've had a couple of questions about summer programming or extended school year services. And one question is, our school is not accepting requests for ESY, extended school year programming. Any thoughts about that?
Well, the state of Connecticut gives guidelines for extended school year, and the criteria for extended school year is based upon two basic requirements. One is about regression. Will your child regress if he or she is not provided instruction over the summer? So that's one criteria. The next criteria is the substantial need, or the, I guess what they say, the extent of the disability. If you have a child that is let's say on the high end of autism and has extreme behavior issues, that is a highly regarded disability, a need for that child to engage in ESY. So with those two criteria levels, it's really up to the PPT to discuss and determine if your child is eligible. But that being said, you are also a member of that PPT. It's not just the school making that decision. So what I encourage and I ask parents to do is to keep a record of their child's progress from year to year, from summer to the beginning of the school year. Also long-term vacations like recess in December. It's about, sometimes it's a week and a half, sometimes it's even over that. Has your child changed from the beginning or the end of that time that before the recess to the beginning of the time that he or she comes back to school? What has changed, and what evidence do you have? Has there been, let's say, a phonics test for decoding or encoding? Was the child given one before he left for vacation and then after? So you can see the difference, compare the difference in vacation times. That is evidence of regression. Some parents don't realize that they can take those anecdotal data and then present that at a PPT to show that the need for ESY.
Excellent points. Had an interesting question. If a private special ed school is not doing what they're supposed to do, what is the parent supposed to do? What's the parent's recourse?
Well, the parents can talk to the private school and try to discuss what the issues are and have them fix what's not working, or they can leave the program and try to find another school that's more appropriate. They're not stuck in that private school. I'm not sure exactly what the issues are that they're not following, but if they're not following an IEP or a plan that they have in the private school, not necessarily an IEP, and the student isn't making progress, then you can definitely try to switch the situation. You don't have to stay there.
Yeah,
I think you have
especially with a PPT meeting, a PPT
Mm-hmm.
placement, you need to request a PPT meeting to ensure there's a provision of free appropriate public education occurring at the private school. If it's a unilateral placement, what Marla said is work it out with the private school, if at all possible.
I was going to say, I think you have to determine why the program is supposedly no longer the right fit. Has there been a change of educators? Has there been a change of a dynamic in a classroom? Can you tease out why a child was at one point succeeding or making progress, but that has now changed? Are there environmental factors, both internally within the school or the district, or maybe within the home, that are impacting the child, and address and look at those factors too? Because a dynamic within a classroom can have a huge impact upon a student's ability to access a curriculum as well.
You may also want to consider asking the school if they would allow an independent observer, like an evaluator, or school psychologist, or whatever the area that the child is struggling in, to come in and do some structured observations. Sometimes it really takes somebody from the outside with a different perspective to see globally what's happening, and not as criticism, but just as an observation of what is going on and why that student is struggling within this environment. It's amazing what can be found, that the teachers themselves don't see. So that's another recourse that you may want to consider.
We had an interesting question. All of them are interesting, I should say. And it's what to do when a school district denies a parent's request for an initial evaluation. Do the parents have any rights when the school denies the initial evaluation? Any thoughts?
Well, first of all, I would find out the reasons of denying an initial evaluation, because the school would be held liable for what we call child find. What that essentially means is that the educational district is responsible for identifying children that have special needs. And so without an evaluation, it would be very difficult to identify the child. So if the school is refusing the evaluation, they are basically saying that they are not seeing any identifiable red flags, so to speak. In that respect, you can certainly get your own independent evaluation and then come back to the school if that evaluation shows that there is some reason for the child struggling, and evidence is the fact that the child does need more than general education, and come back and ask for reimbursement, as well as present the report and certainly invite your evaluator to substantiate the evidence. So you do have recourse, but again, it is a process and you want to make sure that you follow the process.
You also want to make sure that the district doesn't use SRBI or tiered intervention as an excuse or a reason why they don't think the student needs to be evaluated, because they're not allowed to do that.
That's a very important point. The U.S. Department of Education Office of Special Education Programs issued a policy guidance letter 11-07 in 2011, and they just reaffirmed that in April of 2023, that response to intervention tiered programming cannot be used to delay a referral to special education, deny a referral to special education, or delay the evaluation of a child's actual or suspected disability. And these are resources that are available on the U.S. Department of Education's website, ed.gov. That's the Federal Department of Education. And this is all readily available in the world of the internet that we live in today. one question, we had a question last time about playground accessibility, but we had a variation on that question. If the school is older, and unfortunately, I don't know what older is. So the quick answer is, if we're dealing with a public school, they are a recipient of federal funding and they are covered by Section 504. Since 1977, schools are required to be accessible and usable, including extracurricular activities, recess, playground. So if older means that the playground was in existence after 1977, it would be covered by Section 504. But Section 504 uses a different standard of accessibility than the Americans with Disabilities Act. So if the playground was in existence or constructed since 1992, then the Americans with Disabilities Act would apply. So I think I can't imagine any playground being older than 1977 and probably newer than 1992. And the United States Attorney's Office here in Connecticut has investigated playground accessibility issues. The U.S. Department of Education, Office of Civil Rights, sometimes known as OCR, and their regional office for Connecticut is located in Boston, has issued OCR decisions finding discrimination when a playground was not accessible and usable for children with disabilities, because the pathway is made out of wood chips rather than fiber or paved, or the playground equipment itself is not accessible. So there are standards in the Americans with Disabilities Act. There's a federal agency called the Access Board, which has published standards for making play areas, is what they call it, accessible and usable for children with disabilities. So if you're dealing with an older playground that predates 1977, existing construction is exempt. But as I mentioned, I can't imagine a playground being older than 1977, and I can't imagine them being older than 1992 when the Americans with Disabilities Act was enacted for public schools.
Switching tack, this was a question that we were asked before the webinar tonight, and it's regarding the least restrictive environment. And the question is, why aren't there more laws to enforce access to the least restrictive environment for high needs children that public schools often outplace?
Well, I don't know if we need more laws, that we need the proper enforcement of the existing law. The least restrictive environment was part of the original Education for All Handicapped Children Act that was enacted by Congress in 1975. And it means that children with disabilities are educated to the maximum extent possible alongside children without disabilities. And they're only removed from regular classes under exceedingly, rare situations where they cannot obtain a free, appropriate public education in a regular school setting. So rather than more laws, and this has been around since 1977, as I mentioned, we should be enforcing the existing laws. So how do you establish the least restrictive environment? Well, it can be done qualitatively and quantitatively. I just did this, not too long ago, pointing out that the school is saying the placement is the least restrictive environment, but the child is spending about 70% of the time outside the regular classroom. So the rhetorical question I ask is, what's the difference between a segregated public school setting and a segregated out-of-district placement setting? So the least restrictive environment should, in Connecticut, we have a benchmark. It's only a benchmark, it's not a requirement. You'll see on the IEP time with non-disabled peers, and the benchmark is 80%. So the state is looking for IEPs to have children, whenever possible, spending at least 80% of the time in regular classroom environments. Sometimes that benchmark is met, sometimes it's not. But when I see it the other way around, where the student is spending 80% outside of the regular classroom, then I think there's a denial of the education in the least restrictive environment.
Another area that's been a great concern, and maybe in part has escalated since COVID, is school districts quite often are failing to provide the one-to-one paraprofessional support because there has been a decline in the number of people joining the field and staying within that profession. What advice do you have for families that have an IEP that stipulates a one-to-one, but their children are not receiving that regularly or at all?
This is a problem that it's happening throughout the country as well as the state of Connecticut. So it's not atypical, but certainly as a parent, you should be and have the right to be concerned. My suggestion to families would be to, first of all, really look at what your child needs with a para one-on-one. What is the role, or what is the one-on-one para doing for your child? Can those responsibilities be covered by a shared para? That's a possibility. You need to look at different options because you want to collaborate with the school, and we have to understand their situation. If you and the teen feel that the one-on-one para is essential, but there's no one-on-one services through a para within the school, the district also has the option of looking at service providers outside of the school. They're called contracted service providers. There's many agencies out there that have these support people, not just paras. They have OTs and PTs and physical therapists, occupational therapists, speech and language therapists. They have different support professionals. So they can contract for services outside of the school. It's not ideal, but certainly it does provide the gap or the void if your child truly needs that one-on-one support.
Also, if your child is not receiving the support that they're supposed to have based on the IEP, the legal document, then you can file state complaint and you can explain that your child didn't receive a one-to-one para for so many days or months of the school year and ask for compensatory time.
Mm-hmm.
And that's the complaint resolution procedure, the CRP complaint. It's an informal complaint, not a request for a due process hearing. So that's how, as Marla said, you can get the services or the service hours after the fact that were supposed to have been in the IEP.
And a district, so if your child is receiving private services outside of the school day, whether it's with the PT, OT, behavior specialists, and so on, and you wish to invite that private practitioner to join you at a PPT meeting, can the district deny your invitation and decline access to the PPT with your therapist at your side?
You have to go ahead. Sorry.
Never heard that, but I guess it's happening.
Yep.
Yeah. What are your thoughts?
I was just going to say that parents and guardians have the right to invite whoever they feel has appropriate input into your child's education. It has to be irrelevant. It can't, be somebody that's totally, irrelevant, but it's somebody like a BCBA or any other therapist. You have the right. However, the school is not responsible to pay for their time. It is you as a parent, you are invited, just like a parent invites me as their advocate. I have a right to be at 504 meetings and PPTs. I do not have the right to be at teen meetings, although many districts do allow that, but there's no responsibility for the district to allow me as an advocate or any other service providers outside of the district to teen meetings. But yes, to 504 meetings and PPTs, you as parents have the right to invite who you feel is appropriate. And Larry, I'm going to hand it over to you to add to that. So,
Just going to say, even though the name is not on the PPT notice, you can still invite that person. So, sometimes I just got one earlier today. Your name is not on the PPT notice. I said, I'm never invited to a PPT meeting. I take no personal offense, but I'm going to be there. And that's the same for any other private provider, somebody who's knowledgeable. That's all I'm adding to Allie's response. We're getting to a point that unfortunately our questions and comments exceed the allotted time. We're going to be posting a slide at the end of tonight's webinar with contact information for all four of us. The couple of questions: will we get copies of the recording? Anybody who's registered will get a copy of tonight's recording. So I want to thank our two very valuable guests, Allie and Marla, who have tremendous experience advocating on the behalf of children with disabilities, as well as Jane, our co-host. If you found this evening's conversation, questions informative, and a spark thoughts and interest, we hope that you will be joining us next year at the commencement of the 23-24 school year, as Jane and I will be starting our fourth year doing these webinars. We are going to have Dr. Ronnie Cohen-Sandler, a private psychologist. We're projecting our first meeting on September 19th. And Dr. Cohen-Sandler will be discussing issues on mental health and their effects on learning. So until we meet again, Jane and I will keep a watchful eye on issues and events that affect the rights and health and education of our children with disabilities. And as the year progresses, we will add to that with next year's webinars. So I want to thank Jane, Allie, and Marla for your collaborative efforts and insightful thoughts, and look forward to our next discussion. But most important, I also want to thank my daughter, Rachel, for her dedication and her technical skills. Those who've registered for the webinar have dealt with my daughter, Rachel, who helps with the registration. She's off camera, but her fingers are all over the computer, moving things around. So you'll have that slide at the end of tonight's presentation. And so we hope you have a safe and enjoyable summer. Stay safe, and maybe we'll have some fresh air in the next few days with this haze that's all around us. So I'd like to just turn it over to Jane with some closing remarks, and then Allie and Marla. And again, I thank you all.
Thank you, Lawrence. It's been a very busy school year and it's not over yet. We still have a few weeks to go, and ESY as well. And I'd just like to thank Marla and Allie. It's been a great conversation. I'd love you to come back next school year and join us, as we didn't get through so many questions we were unable to have time to answer. And that being said, if your questions were not answered tonight, please reach out to any of us after tonight's webinar privately, and we can see if we're able to support you and help you through the next steps that you might be taking. If you're watching this webinar and have enjoyed the series that Lawrence and I put together, please don't hesitate to let us know if there's topics of conversations that you would like us to discuss next year as we plan for the year ahead. With Rachel's support, she kindly helps us connect with you all. But I also want to give thanks to Debbie, who is Lawrence's wife, and without her coordinating this endeavor, it wouldn't be possible either. So I would like to thank Debbie as well. But please share with us any topics of conversation discussion that we haven't covered either this year or in the last few years. We'd love to explore those with you all as well. So have a wonderful summer, enjoy the break, and reach out to us. We don't all take a break over the summer, regrettably. So we are here to help you throughout the year. I'd like to thank Marla and Allie if you'd like to say some words too.
Yeah,
Just to close. Oh, go ahead, Marla.
I, I was just going to say thank you for having us on all of these meetings. I've really enjoyed sharing my knowledge and working with all of you to present to people who need this information. And I hope everyone has a great summer, and I look forward to seeing everyone next school year. Thank you.
And I too would like to thank you for inviting me. And I also want to let you know that it's always a learning experience for me as well. We don't have all the answers. And these questions really broaden my understanding and knowledge. So thank you for that gift. And I hope everybody has a great summer. And thank you for participating tonight.
So if you just give us a moment, we're going to add a slide at the end of tonight's presentation with our contact information. And with further ado, we thank you all for participating. And we're going to sign off about a minute or so after the slide shows up on our screen. And you will see Lawrence Berliner, Marla Wayne, Allie Grafman, and Jane Faherty. What you won't see is ed.gov and ct.gov, which are the two websites for the State Department of Education and the U.S. Department of Education. Thank you.
All right, thank you.
Thank you.